Members, it's the appointed time and we have a quorum. Let me call the meeting to order. First, Mr. Yiu-chung, the chairman, is out of Hong Kong on some business, so I'm taking his place. Let us invite the administration to come in and then we can look at the minutes. The minutes of the last meeting, held on the 16th of October, have been sent to members and the Secretariat has not received any amendments proposals. I suppose that we do not have any proposed amendments, so the minutes are confirmed. Information papers issued since the last meeting, there are 4, and you should have known which papers those are from the agenda. I won't read them out unless you have something to say about them. Item 3, let me welcome Mr. Raymond Tam and the administration team. Items for discussion of at the next meeting. Mr. Tam, would you like to propose anything about items to be discussed at the next meeting? Yes, thank you, Chairman. This is the first regular meeting of the panel on constitutional affairs of the new term Legislative Council. I'd like to say here that we hope to have the utmost cooperation with members in the work ahead. We'd like to propose 2 items for the next meeting, please. 1, the EAC 2012 LegCo election report. The election was held on the 9th of September. According to the ordinance, the EAC should submit a report to the Legislative Council with regard to that particular election within 3 months, and the report should be submitted to the Chief Executive. So by the 8th of December this year, the EAC should submit a report to the CE on the election of the Legislative Council. I'd like to propose that we take up this item, and that is we introduce to you the contents of the report and the relevant proposals at the next meeting. The second one is on the UN Committee on Rights of the Disabled, and that is the first report and its concluding remarks on the report submitted by the PRC. This convention was extended to the PRC and Hong Kong SAR in 2008, and as party to the delegation of the PRC, Hong Kong SAR officials attended the meeting on the 18th and 19th of September this year, and we also responded to questions raised at the committee meeting. On the 28th of September, the committee reached some concluding remarks on the report as to how the convention should be taken forward and implemented. According to the concluding remarks reached by the UN, the relevant bureaus are now examining the concluding remarks and are studying what actions need be taken. We propose that the LW Bureau staff report on the initial response to the concluding remarks made by the UN at the next meeting of the CAP. May I please propose those 2 items? Well, actually, at the last meeting on the 16th of October, Ms. Emily Lau mentioned that, in fact, she would like to invite the relevant organizations to come and express their views, and in fact, Ms. Emily Lau has written to the panel on the same matter. If you do not object, we can invite deputations to come to the next meeting. Emily Lau, I of course agree that we should invite deputations to come, but you remember at the House Committee I said that we would like to set up a subcommittee to discuss this matter. But the DAB, maybe you yourself also said that they would object, and then Mr. Tam said it is all right, you can come to my panel and there will be ample time for you to take this forward. So I would agree. However, since we have to tackle other matters at the next meeting, if we are going to invite deputations, and not just the deputations that went to Geneva, many other deputations would probably come. So I hope, Chairman, you can find a forum, a suitable one, where people can really come and express their views. Of course, at the House Committee, I did not say that we should just receive deputations, but we should follow up on the recommendations in an inter-bureau, inter-departmental manner. This is one thing. And secondly, may I go on to other items that I would like to discuss at the next meeting? Well, let us do something about this item on the rights of the disabled first. So what do you propose to do, especially if so many deputations would like to come? Is it like what the Bureau Secretary said, that we should only give 1 minute to each deputation and that's it? Well, I think we can extend the meeting by 1 hour next time, and if necessary, we can leave this to be decided by Mr. Yiu-chung, and that is to have a special meeting or to do it in other ways. I'm sure there will be a way to deal with this. I would say that we should have a special meeting because people will be coming, some of them wheelchair bound, and if you give them 1 or 2 minutes, it won't be good. And also you need to follow up on these matters. It's not to be dealt with just by 1 or 2 meetings. I understand. Ms. Sitho, did you raise your hand? Thank you, Chairman. First of all, on the Convention on the Rights of the Disabled, I hope there will be a hearing and other bureau secretaries should be invited, because this is not related just to the Constitutional Affairs panel. This has to do with education, employment, and social welfare and other rights. In fact, it would have been best to have a subcommittee deal with this under the House, but unfortunately that was vetoed. Never mind if it is dealt with here. I hope we will not just rely on the SCMA to listen to the views, but other secretaries should come directly as well. May I now turn to the list of outstanding items? Are we there? No, not yet. We will come back to it. Okay, I will come to the list of outstanding items. Mr. Kenneth Chan. Thank you, Chairman. With regard to matters arising, I am concerned about matters relating to officials and also EXCO members, and also, as you know, one headline of a newspaper is about a potential conflict of interest involving the wife of the chief executive. I hope the administration will face up to these issues soon enough, because it is going to harm our governance and it is going to harm the public's confidence in the administration. With regard to the report from the committee of Mr. Justice Andrew Lee, I think we should really look at those recommendations, and I'd like to listen to the administration's views on the Food for Good Limited, and that is the company set up by Mrs. Regina Leung, and whether there would be any potential conflict of interest. Okay, one of the outstanding items can relate to this, and when we can certainly see when we can deal with that. Mr. Dennis Kwok, Chairman, with regard to the role and functions of the CPU, Central Policy Unit, and also its scope of work, and also criteria for recruiting people, I think the public are asking questions, and I believe the panel should follow up the matter. Right, we'll record that view. Bureau Secretary, any response from you? Chairman, first of all, on the Convention on the Rights of the Disabled, from the staff of Mr. Matthew Chung, I know that they welcome the invitation of deputations to this panel to give views, especially on the concluding observations. If we need to provide more time to receive deputations, I'm sure Mr. Matthew Chung and his staff would be very happy to do so. I believe the clerk can liaise with the LW Bureau and my bureau to see how we can find the time to do this. That's number one. Number two, with regard to the report of the independent committee headed by Mr. Andrew Lee, we said to members in the past that we are now implementing the relevant recommendations. I hope that at the appropriate time, and that is in due course, when our views are mature, we can come back to report to you on progress. As for the CPU, my view is it may not be appropriate for this panel to discuss anything about it, because it is directly responsible to the CE and the CS4A and also the FS. The CMAB has no role to play in this. Whether it is appropriate for the panel to discuss this, I have reservations. Thank you. Ms. Emily Lau. Chairman, if you have finished, I'd like to say something by way of follow-up. Actually, I gave you a paper and also to the clerk, and that is about the declaration of interest and conflict of interest involving the CE, and the clerk has given me a big pile of papers today. There are many things that have to do with declaration which have not been clarified, and he also declares here that he doesn't know why his name is still there even if his directorship has been ended. And he said that he would ask his lawyer to investigate into it. I think this is within the purview of the Bureau Secretary. Of course, the public are very, very concerned about the declaration of interest by the CE, and also his UBW at his residence is a matter of integrity, and he should come and give us an account. So will you consider putting this on the agenda of meetings that will soon follow? Right, we will come to the list of outstanding items. Item 13 has to do with potential conflict of interest, and I think we can have a longer discussion on that. Sorry, Chairman. The item there has to do with the IRC report headed by the former Mr. Justice Andrew Lee. That's one thing. Mr. C.Y. Leung said that he would accept all the recommendations and he would implement those. Yes, we need to follow that up. However, this one has to do with the C.Y. Leung's declaration of interest. You mean you want to lump the two together and have them discussed on the same day? Well, it's entirely open. You can do it either way. You can do it together, or if time is tight, we can certainly deal with them separately. Bureau Secretary. Earlier on, Chairman, Ms. Emily Lau wrote to the administration through Mr. Yiu-chung, the chairman of this panel, on the issue of declaration of interest by the CE. With delegation of power by the CE's office, this morning we submitted the information to the clerk. Maybe we can allow time for members to read the relevant papers before we will take this up with the clerk to see how members would like to follow this up. Earlier on, Ms. Lau and Mr. Chan mentioned the IRC for the prevention and handling of potential conflicts of interest. As I said, there are 36 recommendations in the report, and 17 of those have been implemented. The remaining 10 odd are being dealt with, including amendment to the POBO, Prevention of Bribery Ordinance. We'll waste no time, and when we come back to the panel to report on progress, we will submit the relevant papers and attend the discussion. We'll be watching the situation closely, and we will try to come back to the panel to give an account as soon as possible. Chairman, I have already read the papers. I'd like to place this on the agenda. It is not just for us to read the papers. What do you think? We have already got some items for next month. Whether we like to add more items or whether we would organize a special meeting, a separate meeting, I will ask Mr. Tam Yiu-chung to deal with that and inform members accordingly. Please do it as soon as possible. Please do not delay matters as C.Y. Leung does. Mr. Ronnie Tong, I think you are very efficient, Chairman, but I think our discussion is not focused. It seems we are jumping from one topic to another. I'd like to follow up on the other topic, and that is the role and function of the CPU. I hope this will not just taper off. Just now, the Secretary responded, and I find that response quite strange. Theoretically, the CPU conducts research, and he is directly responsible to the CE and the CE in Council. The CPU should submit research results to the CE in Council, and that would have a direct impact on the governance of the CE. If the CPU has this constitutional status, I believe when the SCMA says there is nothing to do with him, I find this a little strange. Does he mean that only the CE or only the CS4A can deal with this? The CS4A will be here soon, but she is here for another purpose. I think we should have a focused discussion on this, and I believe this will be the right forum to do it. A lot of media organizations are interested, let's say, let us use a neutral term, that they are interested in this. I hope the Bureau Secretary will also agree that we should discuss this at the panel here. If he is of the view that the CS4A should be involved, then we can very well invite her to come. And I can't see which other panel would be the more appropriate forum to discuss this.
Maybe I invite other members to speak before I ask the Secretary to give a reply. Dr. Helena Wong. I'd like to ask about page 5, the amendments to the discrimination against persons with disability, and also the amendments to these legislation submitted by the EOC. Maybe we'll talk about this issue later. Mrs. Regina Yip, this morning the Civil Service panel spent much time in discussing the creation of two new posts. One is a D2 post, and I ask why this issue has to be discussed at my panel, because and the reply is that as usual practice, a D2 post will be discussed at that panel. That's in relation to the Commission on Strategic Development. And the other post concerning the CSD is a D3 full-time consultant post, which is more controversial. The post was discussed at this morning's panel meeting, and it is controversial because it has to do with the role and functions of CSD. If we're talking about role and function of the CSD, it should be discussed at the CPU. It should be discussed at this panel rather than at my panel. And recently, Ms. Sid Ho's motion was voted down at the council meeting, and after that there was a pride parade, which was of a rather on a large scale. Secretary, I understand that you have stated your position, and if I remember correctly, you said that you agree that there should be protection of human rights and equality. And the EOC chairman, Mr. Lam Wun Kwong, also expressed that he supported legislation. So I wonder if any proposals will be floated at a later stage. Mr. Lee Cheng-yen. I also agree that the Central Policy Unit has changed its nature. It has turned into an organ similar to the mainland's propaganda unit. So I think we need to clarify its roles and functions, and posts should not be created before we do that. And now Sophia Cole has been recruited, and it's said that the lists of members of all advisory bodies should be notified. Ms. Cole should be notified of all the list of members of advisory boards. I have checked through all the panels, and I think that this panel is the most appropriate one to discuss this issue. Mr. Alan Leung. Well, just now, members talked about the CPU and the headline of one of the newspapers, and that is a food waste company set up by the wife of the chief executive. I think that these two issues should be discussed at this panel. My reasons are as follows. First of all, whether we should use public money to fund the CPU, which originally only served 3 clients, the chief executive, CS4A, and FS. That is, they conduct studies upon their request. And now I agree with the other members that it has its nature has changed, and it's a change to the system, and it should be discussed here. And about the wife of the chief executive, I think it's like one media coverage of Wan Jiabao's family tree, so on and so forth, and I think the problem is serious. My views somewhat differ from the newspaper's views. I'm not talking about interference into policy matters. But there is a question as to whether the chief executive will, through himself or through his family members, obtain interest. It is a constitutional issue, and I think that it should be discussed at this panel. Ms. Emily Lau, Chairman. Well, as said by Mrs. Regina Yip, today at the PSP we spent great lengths at discussing the creation of new posts. We said that it's outrageous, and we agree that it should be discussed at this panel. And if Secretary says he's not responsible for this matter, then maybe we should ask other officials to come. It's really outrageous. We agree. Well, we should go through the policy and the structural change before any proposal on the creation of posts are proceeded with. And now they have already recruited someone. It is outrageous. You should not ask Mr. Tam, Secretary, to make a decision. You, as Chairman, should make a decision. And about the wife of the Chief Executive, I also think that it should be dealt with here. Secretary, any response? Chairman, as I said just now, Chairman of the panel has the decision in deciding on the items to be discussed. As for officials in CPU, it's not under the Bureau's remit. But if members are interested, I can reflect members' view to the CPU and the CE's office and see how these concerns can be allayed or addressed. Mrs. Regina Yip talked about discrimination against sexual orientation, and in fact, when we move on to the next item, I will also give an account on this matter, Chairman. Well, I'm only the acting chairman today. I think that the job should go back to chairman. As for items to be discussed at the next meeting, we already have certain arrangements. I understand that members are concerned about the CPU, but in terms of emergency, I don't think the matter should be discussed within this week or two. So I think that the matter should be decided by chairman, Mr. Ho. I'm waiting for second round because I'd like to say something about matters arising. I note that on the list of outstanding items for discussion, these are the three items, the first three items as suggested by the administration should be deleted. I see that these three items have already been there for 7 or 8 years, but without any response to by the government, we cannot say that it should be thrown to the rubbish bin. For example, important bill under Article 50 of the Basic Law, when we talk about the development of political parties and the EAC, I think that these matters should be discussed at the panel, in particular the role and functions of the EAC. The administration suggested removing this item because no outstanding action on the part of the administration is required. But my basic request is that at least these three items should stay, and furthermore, the administration should discuss these issues with us as soon as possible. In particular, for the EAC, a report was prepared in 2004, and we already had 3 electoral elections and DC elections since 2004. And many really questioned and offered views on the roles and functions of EAC. So my position is that I oppose the deletion of these 3 items. Just because the administration does not have any follow-up action, it doesn't mean that we should not discuss them here. Mr. Ronnie Tong. I also agree, because there are issues of members' interest, and then at the meetings the administration should come and give an account. It's not up to the administration to decide whether to come or not. If the administration thinks that time is needed for them to prepare the briefing, then we can agree to delay the item, or postpone the item. But I don't think it's appropriate for the administration to say that they would not like to discuss this issue and that the item should be removed. Agony response, Secretary. Well, for the list of items is getting longer and longer. I don't mind that, but for the first 3 items, well, these 3 items have not been discussed during last term's LegCo. For example, for Article 50 of the Basic Law, the administration's position had been stated clearly. So unless there are any new thinking, our position remains the same. As for the role of political parties, the crux of the matter is a discussion in 2005 as to whether a political party law should be introduced. And at the time when the issue was discussed by the media, I also said that we would hold an open mind if the administration was asked to conduct a study on the development of a political party law. And yet we have not heard any such requests since then, and I feel that this might not be one of our top priorities. But if members think that the item should stay, I have no particular position. So based on Ms. Sit Ho and Mr. Ronnie Tong's views expressed just now, and that the Secretary has no strong objection, I suggest that the item remain on the list. In particular, item 3, Chairman, the composition, functions, and operation of the EAC. We have had so many elections, and we have had views from academics and the public. The administration has never stated its position. So shouldn't we discuss this item as soon as possible? Usually after LegCo's election, there would be a report. And I hope that when the EAC submits this report to LegCo, this item should be discussed in one go, and academics should also be invited to speak on the subject. Because it's been 8 years, the society has changed, the elections have also changed, so would like to hear whether there are new thinking and recommendations. Secretary, please note this view. If there are no other questions, we move on to the next item, general overview on the CMAB's policy work priorities. Secretary, please. So for the policy work priorities of the CMAB in 2013, I will brief members on them. As for the part about mainland affairs and bilateral relationship with Taiwan, this will be separately discussed. Since June this year, the administration released a report, and the recommendation was that the DC appointment should be scrapped or abolished in one go by legislation. And our proposal is to amend the DC legislation to abolish appointed seats in one go, so that starting from the 1st of January 2016, at the beginning of the 5th term of the DCs, there will be no appointed seats. After we go through the internal procedures, we will proceed with consultation process, and this panel will also be consulted. Our goal is that by mid-2013, we will be able to complete the relevant legislative amendments. As for elections, we'll continue to work with EAC, and in relation to the recent elections in the past, we would take on board the recommendations of the EAC. We would also take on board views of the community to ensure that public elections will continue to be conducted in a fair, open, and honest manner. The 5th term of LegCo election will take place in DC election will take place in 2015. And on the number of elected seats in each constituency, we will conduct a review. It will be based on the increase in population in that constituency to consider whether to increase the number of elected seats. And we will base our recommendation on the population forecast. And our recommendation is that before the end of 2013, by 2014, we will complete the legislative amendment so that the EAC have sufficient time to make recommendations on the the constituency arrangements and number of elected seats.
And in accordance with the stipulation of the EAC, we should submit a report on the delineation of constituencies to the CE by the 5th of November 2004. And with regard to the Legislative Council election in 2016 and CE in 2017, we will act according to the basic law and the relevant decisions of the NPCSC, and we will kickstart the legislative process in accordance with those decisions, and we'll listen to the views of the Legislative Council. With regard to human rights, we continue to protect and promote human rights. We will be committed to producing publication and other publicity materials, and we'll also keep up our liaison with people of different strata. As for promoting equal opportunities for people with different sexual orientation, we will be doing more. We will plow in more resources in order to do more publicity and education. And also, through the Equal Opportunity Sexual Orientation Funding Scheme, we can subsidize community activities. In the last Legislative Council meeting, many members spoke on discrimination against people with different sexual orientation. Members have also made proposals. In the response speech, I said that the SARG would listen to the views carefully, and we would be tapping the public's pulse and see how things evolve so that the present term of government can know how we can do better in removing discrimination against people with different sexual orientation. As to whether we should conduct some consultation on this, we have an open mind. In the January public policy address, the CE will give an account. On racial equality, the Race Discrimination Ordinance prohibits discrimination, harassment, and vilification on the ground of race. And the Administrative Guidelines on Promotion of Racial Equality promotes racial equality and ensures equal access by ethnic minorities to public services. The guideline and the ordinance are operating smoothly, and we will be keeping watch of their implementation. As for personal data privacy, on the 17th of June, the relevant amendment ordinance was passed. With regard to direct marketing amendments, etc., other amendments have come into effect on the 1st of October this year. We will work closely with the PCPD, hoping that by the second quarter of 2013, we will be able to implement the new provisions with regard to direct marketing and also legal aid, legal assistance scheme. We will work closely with PCPD, and we will invite the PCPD to come and report to members together with ourselves about our preparation work. With regard on LLC stocking recommendations, the consultation ended in March, and we're going to give you the details in the second item of our discussion. As for basic law promotion, we're making use of different media and also activities, as well as cooperation with other programs to increase the understanding of the public about the basic law. As we said in para 15, these are just our rough work priorities. We will continue to listen to members' views in other panels, and we will certainly listen to members. Thank you. This is my introduction. There are now 4 members who have registered to speak. Let me read out the names: Raymond Wong, Jeffrey Lam, Raymond Chan, and Sit Ho. We can have till 3:45 for this item. 5 minutes each. Mr. Raymond Wong. Chairman, the paper says that in 2013, the CMAB will have 7 work priorities. None of them is new. We have 1 human recorder, and now we have a new human recorder from Mr. Stephen Lam. Now we have Mr. Raymond Tan, which is also a human voice recorder. All these 7 items of work have been with us in the past, and there is no progress. First of all, the DC appointed seats and its abolition. In 2005, because the Pan-Democrats used the veto power and vetoed your constitutional reform package, So you carried on with the appointments at DC. You said that because there was no reform. And then in 2011, 1 year before that, the DP of the Pan Democrats supported the constitutional reform package, and yet you did not abolish the DC appointed seats. Whether it be Donald Tsang or C.Y. Leung, the administration has done a nasty job. Abolition of DC appointed seats should be done at one go, and there is no room for negotiation. We told you many times, but then you were saying it would be done in phases, and then you said it would only be abolished starting by 2016. You should step down for this. This is totally within your jurisdiction. This has nothing to do with the basic law. You don't even have to go through legislation. And also, when you did your appointment, you did not have to work according to the ceiling. In 2011, you did nothing, and now you pose as if you are doing something. Of course, there will not be any objection. Look at the pro-establishment camp. They grab all the seats. What are you afraid of? You still appointed the maximum allowed. Only on this one, on this one alone, I can say that you are incompetent. Together with Mr. Albert Chan, I said many times that we should amend the budget in order to cut the spending of the CMAB. This is what heaven would have liked to see done. But of course, this will enjoy no chance of support in this council. What have you done? In the coming budget, I will again seek to cut down on your expenditure. The same goes for CPU. Xiu Shin-po is doing an outrageous job. Xiu Shin-po and Zheng Qi-kong are totally below par. They are worse than Paul Chair. Even if I take on them one at a time, I will always win. The CPU should have academics on it, but now he is saying that it should stage a counter-attack on behalf of the administration. And yet you, Mr. Raymond Tam, you say that you cannot control the CPU. First of all, we have to rebut him online first. And then constitutional reform, we are just marking time. You are still saying that we may be working about the elections in 2016, 2017. Who calls the shots? Come on. You tell me, Raymond Tam, 2017, electing the CE, one man, one vote, no screening, no nomination committee. Dare you say those? 2016, the DP is saying that there should be total universal suffrage. And also the DC supersedes. They will be scrapped according to the DP. Would you like the secretary to respond? No, come on. Let me say one more thing, Chairman. The joint publicity scheme. In the last term, at the CAP, I already said that it was outrageous. There are so many publicity boards. Elizabeth Court together with Starry Lee, Elizabeth Quat together with Lau Kong-wah, and then Helena Wong with James To, and they enjoy one more time free postage. But of course, you wouldn't like to listen to me. The election has passed. Now I have submitted for JR, and you must have received notice that the court has given leave for JR. Just answer this one. Thank you. I think Mr. Raymond Wong doesn't need to be so impassioned and worked up. Let us try to keep a cool mind when we are starting the new term. Please answer me, cut out the crap. Is it that if my JR is supported, will you conduct another election? Are you prepared? Well, we have seen many other JR cases before. Sometimes we win, sometimes we lose. We will work according to the judgment of the court. We will abide by the spirit of the rule of law. Like the other time, we lost the case about offenders being able to vote, and we immediately amended the law and allowed prisoners to vote. So if anything should come from the court and that we should do something, we will certainly do according to the judgment of the court. Jeffrey Lam. Thank you, Chairman. I'd like to ask the Secretary about the promotion of the basic law. We have been reunited with the motherland for 15 years. On some legal issues, there have been controversies relating to the Basic Law. What is your standard for the promotion of the Basic Law? Is it that the public know that there is the Basic Law and that would suffice? Or would you like to allow the public to have a comprehensive understanding of the Basic Law? What kind of rights are protected and ensured under the Basic Law? I know the administration is taking out APIs to promote the Basic Law, but how effective are these? Your promotional effort must not just be based on APIs. You must do a more comprehensive job. People may know that there is the Basic Law, but if they do not know the contents of the Basic Law, that wouldn't be going far enough. Will you consider organizing seminars involving academics and collect the public's views on the Basic Law? 15 years is not a short time, and the administration should have already accumulated the experience. But if you look at what happened recently, mainland couples coming to give birth, that has something to do with the Basic Law. So can you tell us what more will you do in this respect? Secretary, thank you, Chairman. Thank you, Mr. Jeffrey Lam, for your views. Certainly, since the reunification, the SARG has made use of different channels to promote the Basic Law within government. The CS4A heads a steering committee on the promotion of the Basic Law. In recent years, we have stepped up our work. As I said, there is a funding scheme under my bureau to fund activities to promote the Basic Law. But we also ask civil servants, especially the new recruits, to have an understanding of the Basic Law. And we will also try to arouse students' interest through activities conducted for them. In recent years, the electronic media and new emerging media markets are receiving attention, and we actually also do publicity online, including using apps. Mr. Lam mentioned seminars. Just last month, we organized a seminar on the Basic Law on one weekend with regard to external affairs and one country, two systems, etc. The seminar talked about these issues. We will continue to work on this front. We will also try to gauge the public's awareness and the degree of understanding. In the Basic Law, I think the awareness has increased over the past decade or so, but then the figures do not exactly tell us that things are very satisfactory. So we'll continue to work hard on this front. Mr. Lam, recently with regard to mainland couples coming to Hong Kong to give birth, people are asking about the legislative intent of the Basic Law and also the drafting background of the Basic Law. Will there be other issues about the Basic Law that would prove to be controversies? Will the administration also look at the drafting background and the legislative intent of each article of the Basic Law again? Secretary, thank you, Chairman. In the community, the legislative intent of the Basic Law, especially the speech of Mr. Ji Pengfei to the NPC on the 4th of April 1990, that would be very useful reference. And also Basic Law drafters also wrote on the considerations and drafting background of the Basic Law. These books are available in the market. If members have the interest, we can provide the reference to members. But then this is available in the market, and the Secretariat can certainly provide such material to members. But if you like us to provide it, we are most willing to do so.
Mr. Chen Chi-chun, well, we urge the administration to legislate on discrimination against people of different sexual orientations, and the administration said that it's not the appropriate time to do so. But I'm happy to hear Secretary saying that they keep an open mind, and he also said that in the chief executive's upcoming policy address, something will be said about this, and so we will wait for a month or more. But referring back to the paper, let's look at this first sentence. The administration will continue to be committed to protecting human rights, including publication and distribution of publicity materials. So it's all about publication. But if you used to publish 10,000 leaflets, you can now publish 20,000 leaflets. Sponsorship for community projects, well, that means you don't have to do anything. Just wait till the proposals come in and you provide funding. The administration is often alleged of doing nothing, but the administration said that it conducts seminars and so on, but we're talking about legislation. There should not be any more waiting. Have you any education for civil servants on the discrimination against people of different sexual orientation? I ask civil servants, there is none. Will the related organizations like Hospital Authority take the lead in doing something like that? And also earmark funds for the Children's Rights Education Funding Scheme and Equal Opportunity Sexual Orientation Funding Schemes. As I know, there are at least, conservatively speaking, 5% of our population. But how much fund is earmarked for ethnic minorities? As I understand, annually they have over 10 million funding. What about people with different sexual orientation? Probably several hundred thousand. So when you say funds will be earmarked, how much are we talking about, Secretary? Secretary. Thank you, Chairman. First of all, now about civil service, hospital authorities, especially discrimination against people of different sexual orientation. In 1998, there was a code of practice to be abided by the civil service, and we already said that we would step up effort in this regard, and we'll follow up on the requirements in the COP for civil service and other public organizations. As for funding, I said last time that resources would be earmarked, say, for Equal Opportunity Sexual Orientation Funding Scheme. Relatively, little funding has been allocated, so we're going to deploy more resources. And as for the details, I believe that in the budget we will further set out the breakdown. It's all about allocation of internal resources. I mean, is the administration committed in doing that? Because if you talk about publication, you can publish 10 times the number of leaflets, so that the effort might be more. But in terms of ethnic minorities, I mean, comparing to ethnic minorities, do you think that people of different sexual orientation is being put in an unfavorable position? Ever since the passing of legislation a few years ago, we established 4 centers, and at that time, if I recall correctly, $20 million were sought as funding for the 4 resource centers. But now you're not going ahead with legislation. So in terms of policy, what further effort will you make? Mr. Chen, having heard the debate last time, I did bring this issue back and discuss internally as to whether to legislation. We keep an open mind. And as I said just now, the CE will give an account in its policy address in January. I think the more details will be disclosed by then. And if this work is commenced, I think that all other relevant tasks will also be enhanced. We'll start with second round. Any other members would like to speak in the first round? Visit Ho, Assembly Lau, Helena Wong, Yip Kin Yun, Priscilla Leung. Apart from these 5 members, who else? Cancel second round, all right? Anyone for the first round? If not, then Ms. Sit Ho. Thank you, Chairman. Towards the end of the last term of LegCo, I asked in an oral question, I asked whether the Policy Bureau had gauged the views on people of different orientation in the community. The administration had not conducted anything of this sort, so I conducted a study. But it's the scope is limited because we only have limited resources. But I hope the Secretary, having done this study, you would know better the public's views. Because if you only ask employees to explain to employers about equal opportunities, this is not sufficient. There are other concerns, for example, whether after legislation people might be arrested indiscriminately, and the government has abundant resources. So apart from sponsoring projects, you are in the best position with the most resources to eliminate fear and discrimination. On the one hand, you squandered money in APIs promoting NENT development and OALA, but these are actual concerns. So resources should be allocated to this task, which will eliminate fear and concerns in a rational manner. Now I'd like to move on to constitutional matters. For the election methods in 2016 and 17, well, nothing is said in the paper. You said that at an appropriate time, the administration will initiate the process. But we have had this experience. We asked for consultation, and the administration just sat on their hands, and then just 18 months before an election, everything was pushed through, and there wasn't enough time. And we're talking about the LegCo election in 2016, which is coming very soon, and the C election in 2017 is coming very soon as well. So can you start consultation, say, by the first quarter of next year? The other point is about the registration of voters. In the last election, 190,000 voters were excluded from the register. Of course, if they took part in vote rigging, we welcome the exclusion. But some actual honest voters were excluded from the register, including 2 post-80s in my election aid. That's because they were unable to provide proof of address as they live with their parents. They do not have a separate electricity bill account, and in the end they were excluded. And this should be followed up as well. So, Secretary, when are you going to proceed with reviewing the methods for the elections in 2016-17 and the registration of voters? Shouldn't we start now, Secretary? If members may recall, last year, around this time, members expressed grave concerns, and basically, the LegCo's views were taken on board in formulating the methods. And we've already given a full account, and there is also publicity. As for Ms. Ho's case, we have made clear that if the voter is not the account holder of any electricity or water bills, there should be a proof of address, or even if this cannot be provided, a simple oath-taking procedure can be done at the district offices. So if there are any questions, I urge Ms. Ho to forward the relevant case to the EAC. I can't answer Ms. Ho's question on the timetable on constitutional development because I don't have a timetable here. As for the electoral methods for elections in 2016 and 2017, I can guarantee that there will be ample time for consultation. Adequate time will be reserved for that. Ms. Emily Lau. Now, constitutional development. The administration should work full steam ahead. And the CS4A said in the open that she does not hold high hopes because now the OALA had come to the stage. But still, the administration should try its best, and it should start early. It should not be left till the last minute, or it will be a dereliction of duty. As for the DC appointment system, yes, of course, it should be abolished as soon as possible. It should be abolished long ago. But we're not only talking about appointed seats, we are also talking about ex-official seats, because every member should be returned through direct election. And Secretary, you should do something about it. This should not be left outstanding. On people of different sexual orientation, I hope that the administration would proceed with legislation so as to eliminate discrimination. Next March, the UN committee will hold a hearing, and I hope that the Human Rights Committee Commission will urge the administration to actually do something. According to Ms. Ho's study, we're seeing fewer and fewer opposing voices, and that is only some 30% of the people opposed in the EOC study. But according to Ms. Ho's study, over 60% were for the legislation. Only some 10% opposed the legislation. So we're talking about basic human rights here. Why do we have to wait for 100% to agree before we can offer protection? And also on election-related investigation cases, the progress has been very slow. I also talked to the ICAC, and I hope the Secretary would take note of this as well, because it's about the integrity and probity of our elections. Because if this can be done quickly, you will give people an impression that the administration is committed to tackling these problems. If these cases are stalled, then people will have an impression that they can go ahead with vote rigging without having to face any consequence. This will send out a very bad message. Secretary, now on the DC appointment system for the ex-officio member, next year, around the first quarter, we will table a bill to abolish these seats. We hope that we propose to abolish the appointed seats in the bill. And as for ex-officio seats, well, members' views are diverse, so the case is more complicated. My suggestion is that we should go ahead with abolition of appointed seats first, because very soon the elections in 2015-16 will be held, and I think there will still be time for us to discuss the other matter. So we should deal with the number of elected seats and other electoral arrangements. This is the first step. And we'll come back to listen to members' views. As for election-related cases, well, I can follow up on it and see what the progress is currently. I have this impression that there have been cases on conviction when offenders were sent to imprisonment by courts. So to a certain extent, these cases already serve as deterrents. But I'll go back and follow up on this issue. Chairman, of course, ex-officio members should not exist in the 21st century Hong Kong. You always talk about the lack of consensus and then you should do nothing. Well, that's really kind of you. You get such a fat sum of pay. You say that this should be dealt with in one go. I hope that by 2015, all appointed seats or ex-officio seats can be abolished. Secretary, will this be your goal? As I said, a bill will be tabled very soon to abolish appointed seats. As for other seats, we will discuss the way forward. So will it be done in one go? Will it be done in 2 stages? At least we will have 2 bills. In the coming 1 or 2 months, we will table the first bill for discussion. That is for the abolition of appointed seats.
Then we'll look at the demographics, and then there will have to be other amendments relating to the 2015 DC elections. And by that stage, we can take on board the other view of Ms. Emily Lau. Ms. Helena Wong, 2 questions, please. Just now, 2 other members have asked about a timetable for constitutional reform. Mr. Chairman, I find it most regrettable that the Secretary today is telling us that there is not such a timetable. You should remember, when you were the Secretary in the last term, the Coalition for Universal Suffrage was asking you for the timetable, and then you said that your term of government had not been delegated with the authority to work on the timetable for 2016 and 2017, so we had to take it up with the central authorities. And now you occupy the same seat, and yet you tell us you do not have a timetable. The experience is that for the 2012 election, you had to legislate locally in 2010 because there was this 5-step procedure. Now that we have the timetable, and that is in 2016, there will be the legislative election, and yet we don't know how it will be conducted. In 2017, we will be electing the CE. This is what the NPC-SC said, that Hong Kong could elect the 2017, but then we do not know the method. We do not even have the nomination committee. And now you're telling us there is no timetable. If you have to legislate locally 2 years before 2016, that is 2014. And if in 2013 you're still not triggering the process, I think that is unimaginable. Are you thinking of, come 2014, you will trigger the first step of the 5-step procedure? When will the first step be taken? That is for a report of the CE to be submitted to the central authorities. Is that no consultation with the public is necessary, you think? I hope that when you come next time to our meeting, you will come with a timetable and a roadmap for triggering the election methods. Secondly, about the sexual orientation discrimination. From your paper, it seems you don't really understand what is meant by discrimination against people with sexual orientation, which are different. The EOC and women's groups have given you many views, and that is that the scope of sexual harassment can be perfected. One of the issues is that sexual harassment is such that there should not be sexual harassment in the supply of services. The loophole now is that it doesn't tackle sexual harassment made on the service supplier by the service receiver. If you don't understand, then I can give you an example. The air hostess cannot harass the airplane takers. But then if a passenger on the plane should sexually harass the air hostesses, then that is not banned by law. The same goes for beer promoters. And all these views have been expressed many times. They should have reached your office. But now you say these are either technical amendments or there would be a rippling effect affecting other ordinances, and you don't know what to do and you have to think about it. But then the EOC gave its views in August 2011. And yet you still do not know what to do. You don't have a timetable to deal with this. Does it mean that these victims should continue to live with sexual harassment? I find this unacceptable. If you don't understand what is sexual harassment, I would be very happy to discuss it with you here at the panel. Secretary. Thank you. When I have more information on timetable for constitutional reform or development, I can give you an account. It's just that at this meeting, I cannot give you any concrete timetable. But on the 17th of October, the CE also said that this will be triggered in due course. As for sexual harassment, I agree with Dr. Helena Wong and her concern. I can go back and take another look. And we will look at the Bureau's considerations and also the EOC's considerations and see whether they tally. Chairman, you are a member of the EOC. We'll try to see what can be done, and we'll come back to the panel as soon as possible to give a report on our thinking. Thank you. Mr. Ip Kin Yun. Chairman, I'm also very concerned about elections in 2016 and 2017. I'm sure this will prove to be very controversial, and therefore you have to start early the consultation and other initiatives. I'd like to ask two other questions. One, the nomenclature of CMAB. It seems mainland affairs should be an important part of your job. My question for you is the relationship between the SAR and the mainland's authorities, and also the SAR community and its relationship with the mainland community. It seems a lot of conflicts have arisen. I don't know whether the CMAB should also avail itself to these concerns. Recently, the 18th Party Congress, in its political report, it is said that we should watch carefully the interference into Hong Kong affairs by external forces. And also Mr. Lau Shiu-kai, the ex-head of the CPU, said that he was worried whether Hong Kong would become a subversive base against the CPC. And also with regard to parallel traders and mainland couples coming to Hong Kong to give birth, there have been many social conflicts. I don't know whether that can be subsumed under a policy area, and whether the CMAB will place emphasis on this part of its work. Secondly, para 8 of the paper. It talks about promotion of human rights. Of course, I think this is important. But the way you are presenting it, as other members have pointed out, this is just very piecemeal. You talk about publicity and education and that's it. But I believe you should do more, including through formal and informal education. My question is, what kind of resources are we talking about? Do you have dedicated manpower for this? And also in terms of the way to do it, you have said that with regard to mainland and moral and national education subject, you said that delegations of students should be sent to the mainland, etc. So this time around, would you also put students in groups so that they can go to the UN to study about human rights? In other words, can you do it in a more organized manner and also with more strength? Secretary, certainly things that relate to the mainland is for this bureau to coordinate. And also the CS4A heads social economic exchanges with the mainland, and we act as the secretariat for that job. But then the concrete policy areas would be followed up by the relevant bureaus. Say, for example, CEPA will be subsumed under Mr. Greg So, the CED Bureau. At another panel of LegCo, actually tomorrow, at the CI panel, the relevant ETOs all over the world, including those from the mainland, will be reporting to members their work. Mr. Ip mentioned so-called mainland Hong Kong conflicts and whether we should provide more explanation to allay the concerns. Now, I believe we can give an account tomorrow. As I said at the beginning, today we would be concentrating on elections and human rights. As for promotion of human rights, I must apologize in that our paper has not touched upon an important area. We have two independent statutory organizations, one the EOC and two the PCPT, PCPD. And in fact, my bureau gives them their annual funding. We will regulate EOC and EO and also personal privacy through legislation, and they have their own roles and functions. Like the EOC, we have given them like $90 million for this year as their operating expenditure. And also with regard to the PCPD, I don't have the exact figure, but then it's also in the tens of millions. The Bureau just operates these funding schemes. 2 years ago, originally ethnic minorities was also subsumed under our Bureau. But this has been hived to the HAB, and the funding and staff resources have been hived off to the HAB as well. And they would also look after new arrivals from the mainland. So we do have a certain amount of money for such work. And I'm sure in 1 or 2 months, when we start to discuss the budget, we can give you more concrete figures for reference. Ms. Priscilla Leung. Thank you, Chairman. I have 2 questions for the Secretary, including making some remarks. Just now, members have talked about legislating against discrimination against people with different sexual orientation. I think this is different from ethnic minorities. Basically, there is no controversy attending ethnic minorities. However, legislating to put an end to discrimination against people with different sexual orientation, there has been so much controversy. And recently, I have received a letter. I would actually ask this person to copy the letter to all members. Last week, after our debate, this person is a parent, and this person said openly that this person would not agree with homosexuality or sexual relationships involving more than 2 people. And this person said that after saying that in public, this person was crazily attacked online. This person's parents who have died have been mentioned in the attacks. This person is living in fear. This person says, I hope this person will copy the letter to all members. Now, after reading these views and after listening to Mr. Raymond Chan is asking the administration to inculcate the views also in the Bureau. But you know that this is still very controversial. Can we not allow a morality issue be dealt with in a moral way? I have received many opposing views about legislation. This is not the same as ethnic minorities. And this person is saying that people who are opposed to such legislation should have some latitude to express their views, that their views against homosexuality should be respected. Frankly, I have not just received this letter, but this person has written in, and I'm asking this person whether the letter can be copied to other members. I have received many such views. In fact, certainly, those who support homosexuality may be computer savvy, but I would appeal for mutual respect since this is still controversial. And since Hong Kong is a dominantly Chinese society, people are just saying that they do not agree. They are not saying that you can't do it, and they would just like to have some room for the expression of their views. I hope the Secretary can also take on board my view. I believe he has received similar remarks. I can tell this person to copy the letter to all members. Another question, and I have also followed it up last time. In the last election, over 200,000 people have been disenfranchised. Some of them just did not know why. They lost their eligibility. They just moved hostel in a university. It's just that they did not respond to your letter, and so they were disenfranchised. I believe we should solemnly follow up these issues. Before this happened, I remember in April, May, we already said to the secretary that if you write people a letter and ask people to reply, and if they do not reply, you disenfranchise them. We have already said that there would be many people who would be stripped of their eligibility to vote without knowing why. Many of these people would have always enjoyed their voting rights, and I said you should review the situation. Would you dig up who these 200,000 people are? Have they died? Have they temporarily left Hong Kong so they did not reply? Or is it just that they moved hostels? And in the end, they are disenfranchised. I hope you will be solemn in tackling this. Secretary.
Thank you, Chairman. Let me talk about voters' registration first. We, through various channels, such as TV, radio, newspaper, as well as direct mailing to several times to over 300,000 voters. We urged voters to inform the Electoral Affairs Office of any change of address. And in the first half of the year, hundreds of thousands of voters were able to retain their eligibility. And there were 203 or 300,000 voters who informed the office of the change of address, because Hong Kong people move all the time, and we will step up our effort in asking voters to inform us of the change of address. As for the voters register, we were of the view that administrative measures should be deployed to ensure accuracy of the voters register. And that's why we sent letters on a couple of occasions to verify the address of voters. I believe that voters also have the responsibility of ensuring that the address with which they register should be the most updated one. And in fact, for the voters concerned, they were only required to fill in an up-to-date address form to the Electoral and Affairs Office. Of course, if necessary, the office will also check and verify the accuracy of the address. I believe that all our measures could respond to public's concerns, and we were able to strike a balance. And the report to be released next month will also touch upon this issue. Of course, we'll further listen to members' views then. I'd like to make good use of the time. I hope Secretary would take the lead and take the initiative and actively do something about publication. Well, Mr. Leung Kwok Hong, you came after I've drawn the line, so you and myself won't have time for this item. So we'll move on to the next item, and I'll invite the administration in.
May
I welcome Mr. Gordon Leung, Deputy Secretary for Constitution and Mainland Affairs. So, without further ado, DS, would you like to brief us on the paper? Thank you, Chairman. This paper seeks to brief members on the views received on the consultation paper on stocking and the views collected during the consultation fora by the administration. The consultation took place between December last year to the 31st of March this year. Basically, the public was consulted on whether legislation on stocking should take place. We received altogether 506 written submissions, and 46% roughly supported the introduction of an anti-stocking legislation, and about 35% oppose, while the remaining do not indicate any general support or objection, or render support subject to substantive revisions to the formulation of the offences. And that means, for example, some defense should be introduced for some specific act, or some act should be excluded from the scope of legislation, or some revisions made. And the public's views were quite diverse on this proposed legislation. A key focus was the impact that the proposed offense might have on press freedom and the freedom of expression. Some 40% of the 506 written submissions were related to this focus, and some 15% support the reasonable pursuit defense and believe that this should suffice, while the remaining 85% thought that the reasonable pursuit defense is not sufficient. And there are several major reasons for those who oppose the legislation. First of all, in terms of the scope of offense, there were views that the scope was too wide and the definition was too vague, so that news gathering activities might be regarded as unlawful. The other view is that the person being pursued by the media might make use of the element of alarm and distress and seek help from the police, and therefore the news gathering activities might be disrupted. This might not move further to or to court proceedings, and this defense, although available, might not be put to use. But on the other hand, the news gathering activities would be hampered or obstructed. Some journalist bodies were of the view that much resources would have to be spent in putting up a defense for their news gathering activities. And on reasonable pursuit defense, regarding its definition as to what is reasonable, it was quite vague, and the process may be abused, and these are the grounds of objection by journalist groups and organizations. We have also received views from professional legal bodies. The Hong Kong Bar Association opposes the provision of a separate defense for the press because this defense can be easily abused. They think that if the conduct is not reasonable within the meaning of the proposed defense, then it is unworthy of being such as to be exempted from criminal liability. The Law Society of Hong Kong suggests that the reasonable pursuit defense be amended to the pursuit of the course of conduct, so on and so forth, to cover all legitimate news gathering activities by journalists or members of the press. As for other groups like artist group and women's group, basically they support legislation, but they also think that a proper balance should be struck in addressing the public's concern on the legislation and the impact on news gathering activities. All in all, we attach importance to the concerns raised by various bodies on the news gathering activities, and the legislation also has to do with a number of issues like basic right and personal privacy, and therefore we will carefully consider all the factors, and in providing better protection to those being harassed, we also have to give room for news gathering activities so that they have freedom of press and freedom of expression, and that the news gathering activities will not be affected. We will study the views received carefully with a view to formulating an appropriate way forward. And at the next stage, we will account to the public our way forward. So much for our presentation, Chairman. We have Mr. Wong Yuk-man, Claudia Mo, Helena Wong, Emily Lau, Ms. Sid Ho, and Mr. Chen Kin Po, and Mr. Leung Kwok Hong in the queue. Mr. Wong Yuk-man, Chairman, this LRC in the last century has been studying into the introduction of anti-stalking legislation, and 12 years later, in the year 2000, a report was released, and 12 years down the road, we still do not have a consensus in the community. Just now, DS already gave us a briefing. Why is it that nowadays we really need anti-stalking legislation, and yet we still have not had any consensus in the community? I can only come up with one explanation, and that is we do not trust the government. We do not trust the SAR government, and also because of the human rights situation after the reunification, and our freedom in expressing ourselves have deteriorated. There are sufferers of stalking activities, but freedom of press should be safeguarded to protect human rights. So if there is a blanket anti-stalking legislation, you won't be able to see news like Mr. Paul Chen driving after he'd consumed alcohol, so to speak. I have been in the media sector for over a decade. I oppose a comprehensive or blanket anti-stalking legislation. I'm also a victim of stalking. I think this may happen to anyone in this chamber here. You're target of paparazzi. Not only targets are, but you are as well. And I am a victim of stalking because my grandchild had been followed by paparazzi since the age of 1, and he is now 5 years old. And this has to be exposed by the next. And that's the next media. So who should be responsible should anything happen? I could only ask my family members to report to the police, and I could do nothing to defend myself. I'm outpowered. I am overpowered by Mr. Lai. So I'm against anti-stalking legislation across the board, and in particular, reasonable pursuit, defense, etc. All these are unreasonable. We're caught between a rock and a hard place. Of course, paparazzi is very nasty. They act in the disguise of freedom of press, but in fact what they're doing is yellow journalism. You cause all sorts of family problems, family crises, and then they get happy if they if their publication can sell. So I really believe that Mr. Lai will get his will have to bear consequence. But there are times when journalists have to resort to different means in order to dig out the truth. Would you like the administration to respond? I'll just give my views. I don't think he can respond to me, so I will use the remaining 1 minute. I think that we can amend the existing legislation appropriately to address the concerns in the community. For example, artists or unscrupulous resumption of flats. For example, a few days ago, we discussed with the government about debt collection, and it's really outrageous. cause great nuisance and threat to your family members, but they're not breaking the law. So I think a separate legislation should be enacted for this purpose. If you have a blanket anti-stalking legislation, however, I really don't see the point, and it's been over 10 years since year 2000. Ms. Claudia Mo, I'm not a member of this panel, but thank you for giving me this chance to offer my views. In year 2000, initially there was a proposal to criminalize discrete shooting, because people thought that it was right to enact such legislation, because if it was done secretly, it's not appropriate. And the Journalists Association thought that it was not appropriate at the time.
And then people said that we could advance the defense of public interest. But then if the journalists are gathering news, you already say that I spy on you. And then you say, if anything, I can tell the judge. Well, there is no way I can do news gathering. Here, the stalking proposal is still the same. Many people might say, if you're talking about domestic violence and debt collection, and also disputes between lovers or couples, people might think that it is right to legislate, as long as you exempt the journalists, as long as they can advance defenses. But even the Bar Association and Law Society have differing views, and therefore you can see how big the controversy is. If you say it's all right, don't worry, the press are exempted, they can continue to gather news. But as you said, in the majority of cases, the so-called victim can always call the police first, as long as they are followed by a reporter. They can say that they are alarmed or distressed. It is not a matter of taking the journalists to court, but to stop the news gathering. So what will happen to the entire media sector? And people can say, tell the court. Well, even if people will go to court, the shadow would hang over their head from then on. And no, let's not talk about the court. You cannot even gather news. You talk about exempting the journalists. What about online reporting? What is the exemption? If people will always say, I'm from this radio station or that radio station, and online journalists do not even have to be licensed or registered. If you provide the exemption, everybody will call himself or herself an online reporter. We have done some research. Existing law is such that some paparazzi have used long-haul device to film an artist 1 kilometer away what she does outside the house on the veranda, and the reporter was penalized. And also, if someone follows or stalks a news reporter, a female reporter, that person was penalized. So why can't you just act according to existing laws? And also, after you have collected the views, now what is your next step? What is the timetable? 2 questions, DS. Chairman, on one case where the reporter did stealthy reporting of filming 1 kilometer away, I understand that the PCPD made a ruling, but then the case is being appealed against, and we can all wait to see what happens. As to the next step, the administration's view is we will be studying all the views carefully. From what we know, since the issue of the consultation paper, there have been some changes to the laws overseas. Like in the UK stalking law has evolved. We will look at that. We'll also carefully look at the views collected, and we'll also make reference to overseas experience to see what the next step should be. Chairman, can I ask for a timetable? Do you have a timetable? Not now. We don't have any concrete timetable now. We hope we can really study into the matter. As we said, This has to do with basic rights, including freedom of the press and privacy. We would like to do a more detailed job. We don't want to confine ourselves with a timetable. Dr. Helena Wang, Chairman. Women's groups are in a difficult position vis-à-vis this stalking issue. In the year 2000, the LRC issued a consultation paper on stalking. Many women's groups then supported legislating against stalking, particularly stalking of women. The thing is, we have another round of consultation this time around, and as you said in para 23, many women's groups are distressed. On the one hand, they agree that stalking of women should be regulated, and if particularly that involves into sexual violence, then they hope that this will be criminalized. But then women's groups are also worried that you might overdo it and you might be controlling press freedom. And you also say that a joint submission from 9 women groups casts doubts on the motive of putting forward the offenses of collective harassment, blah, 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 in order to use it as a pretext to curb press freedom and the freedom of expression or demonstration. So how are you going to balance these two sides? On the one hand, you want to protect women's interests and to stop stalking of women, but at the same time, you would also be curbing press freedom. I believe other women's groups, including the DP, would oppose as well. So are you going to bundle up all stalking behavior and resolve it with a piece of legislation? Because I can't see how you can do it and how you can strike a balance. If you say if you have this, you should also have that. In other words, you would curb the press freedom as well. Well, I would rather not have the legislation, even as I speak as a woman, because we don't want to be stalked, but we don't want press freedom to be curbed either. So the only thing you can do is to separate the two. Stalking of women and also sexual violence should be separately dealt with, either in a separate piece of primary legislation or under domestic violence laws. If the two are still bundled up, then you have to consider exempting news gathering. So I like the administration to tell me which direction you are pondering of taking. Chairman, first I have to state clearly that the administration definitely has not bundled up protecting women with curbing of press freedom. Absolutely, that is not the case. The administration is not saying that we want to use the stalking law to suppress press freedom. Your concern now is if we act according to the LRC proposal, that will be the byproduct or side effect. And in fact, the public have registered the same concern. That is why we stated at the beginning that we are equally concerned about this. We don't want that side effect to come about in order to have press freedom suppressed. Dr. Helena Wang made 2 proposals for the way ahead. One, that we do not have a broad brush approach, but rather we only focus or target on certain relationships, like, for example, as mentioned before, couples, lovers, or husband and wife. Maybe we can legislate about that separately. That was a view that was advanced. And then we might also consider providing exemption to the press. What we have seen done overseas is that they have not done either of these. But then whether Hong Kong should go for one of these, we can look into that. And that is why, as I said, we would be looking very carefully at the laws overseas because they have had the laws for quite some time, and would like to see how effective they are and whether they can suit the Hong Kong circumstance with or without adjustment. Helena Wong, does it mean that you have no inclination whatsoever? That is, whether you go for the separate legislation option or for an across-the-board legislation with exemption. The administration has no view decided yet because, as I said, the Bar Association has got its own views. And that is the definition of the term, whether we can think harder about it. We will also give some thought to this. Just one more word. When will you come back to the panel to give us a report? I responded to Ms. Claudia Mo to say that for the time being we do not have a timetable because we want to give some serious thought to all matters concerned before we come back to give a report to the panel. Emily Lau. Chairman, I hope the administration will understand that actually many conflicts and contradictions have been laid bare in the last round of consultation, and you can explain to the Bar Association the worries of the media. In fact, I know the Hong Kong BA knows the importance of the freedom of the press, but then now they seem to be reacting too much. I hope you can find a way to legislate with a narrower scope. We asked for a council on alimony. You never wanted to do it, but you really have to tackle the stalking of women. Others, of course, are the targets of debt collection. However, perhaps you can work with a narrower scope. DS, is it that you have had some kind of consensus on that side, and so you can decide on taking some action earlier? DS, narrowing the scope of the crime can be one of the directions for this to go forward. But then there are views saying that this will not suffice. As we were saying, if you want to narrow the scope, then how narrow should it be? It will be easier to define husband and wife, ex-husband and wife, and intimate friends involving a male and a female, or ex-lovers. But as you know, stalking can take different forms. Sometimes stalking is done on a person you don't know. What about those? We have to think about all these to find a possible way out. Emily Lau, I think you have to decide when you have to come back. I think only with a timetable will you focus your thoughts. It's just like, if you are subject to the death penalty, then you will want to work hard before that. But of course, it's not the death penalty for you to come back. But DS, can you come back within 2 to 3 months? DS? I really cannot promise a timetable. I can only promise that we come back ASAP. Let me add why I'm saying this. As we said, we would like to make reference to what is being done overseas. In fact, the LRC also made reference to the implementation of laws overseas. Now, some time has passed, and the proposals were based on overseas laws which were newly made. And now some time has passed. We like to take another look at the implementation of similar laws overseas and take stock of their experience, whether their laws have been amended in the light of experience. Initial research done recently has told us that in certain places, when laws are applied on stalking, there have been some implementation problems, and that experience is valuable, and we'd like to look into that in detail. Mr. Ho? Chairman, I object to an umbrella stalking law because it would affect freedom of speech and freedom of the press. As Helena Wong said, in the year 2000, many women's groups objected, but recently women's groups would know that an umbrella law on stalking would cause even more losses to the public, and that is why they are objecting. However, in the last round of consultation, we said quite clearly that some existing laws could in fact also regulate stalking. One, the Landlord and Tenant Consolidation Ordinance, the other one, Domestic Violence Law, and 3, debt collection laws, where harassment is posed by debt collectors. If you work on these definite relationships and tackle stalking in these relationships, we would all agree. And you should do it fast. The last term of government said that even if we do that, we would not be able to stop stalking where there is no family relationship. Say, for example, people still are not husband and wife, but then there is stalking, and in the end, it evolves into violence. But in the UK, we have seen laws saying that there must be the threat of violence before there is a crime. It is not just harassment. You have to have the evidence of a threat of violence. And we said that that can be discussed. We think that that would help. If you should write a love letter or an email, if there is an indecent wording so people are disturbed, well, that has nothing to do with news gathering, and we are quite happy to discuss that with you. So in terms of overseas legislation, the existing legislation, and also the certain definite relationships where there could be the threat of violence and stalking, can you not tackle those relationships separately?
Thank you, Ms. Ho, for your suggestion. Ms. Ho talked about a number of points and offered her views, so we will also consider these views. Well, from overseas experience, we see that initially the scope or the definition might be wider, but now they have, to different extents, narrowed down the scope, and for example, with the addition of a condition of the nuisance being developed into a threat of violence. We will consider these examples and see if Hong Kong should adopt this approach. Well, these suggestions have been made long ago. For example, letters with razor blades inside, etc. These are very serious harassment or nuisance, which might very well be developed into a threat of violence. And this would not happen in the course of news gathering activities. So if you really want to stop stalking and protect the freedom of the press in monitoring the government at the same time, you should consider these points, and I hope that you should come back as soon as possible. In cases like domestic violence, resumption of flats, and etc., these can be made separate. Anything to supplement? No, Mr. Chan Kim-po. The paper summarizes the outcome of the consultation on stalking legislation. Well, many groups support the introduction of legislation. Only 35% oppose. Well, the government do not have a clear stance. The government will ensure that the balance be struck so that the freedom of the press and debt collecting activities, so on and so forth, will not be affected. But ever since the report was released by the LRC in year 2000, the administration has not made up its mind what to do. The community has this consensus that stalking is serious, but the administration is still sitting on its hands. So the administration my question for the administration is whether to go ahead with legislation or to conduct a major survey. For example, there are concerns raised by the financial services sector, and some marketing activities may be regarded as stalking, and they may be prevented from these carrying out these marketing activities. So I'd like the administration to explain whether the present proposal will affect or even hinder marketing activities. Would some regard such as stalking activities, so that overall speaking, all marketing activities would have the stand, and will there be any conditions or exemptions available? Yes. As set out in the paper, the views received from this exercise show that, in general, there is support for regulation or legislation against stalking. The major concern is whether the innocent ones will be affected, in particular, freedom of the press. So the administration is going to consider further whether to legislate and the different approaches to legislation. For example, as mentioned just now, some suggested regulating acts that could be easily defined to be stalking behavior, and these should that can be made separate. For example, as suggested by women's group, domestic violence, resumption of flats, and debt collection. On the other hand, some suggest whether any exemptions should be given under the law. For example, news gathering activities by members of the press. And as for aggressive marketing activities, whether exemptions should be given as well, I think this is subject to consideration. We think that we should think about this issue comprehensively. For overseas jurisdictions, they have had stalking laws for over a decade or so, and they can offer valuable examples for our reference. Regardless of our way forward, the administration will definitely come back to LegCo to report to members and invite members to submit further views. So members can be reassured we're not going to hurriedly push through anything that is not acceptable by the community. Mr. Leung Kwok-hong. Chairman, I think stalking behavior is not right. For example, debt collectors. Well, banks, they casually ask people to take out loans. I very often receive such calls, and I say that I would like to take out a loan of 200 million. And as soon as they hear that, they hang up. So this kind of behavior should be stopped. You keep on saying that you'll make reference to overseas jurisdiction. I hope that you could come up with an analytical report as soon as possible. Our concern is that freedom of the press will be affected. The innocent ones will be affected. In overseas jurisdictions, well, you're already seeing a major scandal involving eavesdropping. So I think we need that analysis, because we're legislators, or at least we pretend to pass legislations. If you don't table the legislation as soon as possible by 2016, I cannot guarantee whether the legislation can be passed in time. So we should prepare such a report as soon as possible. I think freedom of the press in other countries is not the same as freedom of the press in Hong Kong. You never see anything like a journalist yelling at President Mr. Hu, and that get arrested in other countries. So to allay our members' concern, you should prepare an analysis on how media in other jurisdictions will be affected once the law is implemented, and what lawsuit may come by. Well, actually, I am stalked. Right now, I receive hundreds of calls a day. I don't know what's going on. Well, whether the calls amount to stalking, I don't know. there is no caller display, so what should I do? Nothing but to call the police. But the point is, it's useless to report to the police because it's not really stalking as such. You can reject the calls. I understand the arguments from both sides, but if you can fix the issue with freedom of the press, I think that we should go ahead with legislation. And please tell us in the report whether you have considered making separate offenses. Yes. Thank you, Mr. Leung, for your view. Now, Mr. Leung talked about analysis in the report, and of course these are things that we should do. Yes, please do it as soon as possible. When will we see that? We will do it as soon as possible. Well, time is almost up, but Ms. Helena Wong would like to ask a follow-up question. So please be quick. I'll give you 2 minutes. Thank you, Chairman. I'm happy to hear that the administration also note that we would not want to affect the innocent. Well, just now you talked about the married couple and the lovers, etc. I am quite concerned. I hope the administration would note that if you want to offer protection, then any stalking behavior between a heterosexual couple or a homosexual couple should be regulated. And for people with intimate relationships or strangers, they should also be protected. Anything to supplement? Yes, no. Thank you, Dr. Wang, for your comment. AOB. Nothing under AOB. Date of the next meeting. 2:30 p.m. To the 17th of December. So because we have a lot of deputations, the meeting will be extended till 5:30. It will last for 3 hours. So can you disclose national secrets? No, I'm not clear about that. If there's nothing on the AOB, meeting adjourned. Thank you.